This leaves no other course than to dismiss the accusation regarding the charge of criminal organization. It is not the role of the Supreme Federal Court to make a political judgment about what is good or bad, convenient or inconvenient, appropriate or inappropriate. On the contrary, it falls to this court to determine what is constitutional or unconstitutional, lawful or unlawful. This leaves no other course than to dismiss the accusation regarding the charge of criminal organization. The Supreme Federal Court, in plenary session, has never addressed this complex matter, this set of complex crimes. On the basis of these well-founded arguments, so clearly set out by His Excellency the Prosecutor General of the Republic, who knows perfectly well, through his daily conduct, that dissent is not discord, even if the agents discuss for several months, in theory, whether or not they should commit a particular offense. The case falls within the realm of moral and social reproach, but it does not allow for the intervention of criminal law. If the agents eventually decide to carry out acts in the planned offenses and begin their execution, they shall be held accountable according to their respective authorship and participation. Mere possession is not enough. There must be evidentiary elements concerning the actual use of weapons in criminal activity. We must set an example. For the first time, we are undertaking the most in-depth analysis of a new offense. And recently, in a plenary session, when we were discussing the absurdity of returning goods, the products of unlawful conduct were confessed by the offender, who admitted to having acquired the goods with the proceeds of crime. At that time, it was mentioned that this is a new issue that will evolve progressively. Some may say, he is a former president, but he is being tried as such, because if he were no longer a president, the case should go to a first instance court. But is he being tried as if he were president? Yes, he is. If he is being tried as though he were president, then this action should indeed begin in the plenary session of the Supreme Federal Court.